Hi future lawyers, and today it's time for a little CA celebration. Common law, equity, and statutory law. Whether you are a new attorney or still preparing for the bar, understanding how these three interact helps you see not only what the rules are, but where they come from. So first of all, what is common law? It is important to note that although common law originated in medieval England, it has evolved in the United States to fit our legal realities. At its core, common law is built on judicial decisions, precedents that evolve through time. Judges interpret and apply the law, and those interpretations become part of the legal system itself. It started in medieval England, where royal judges traveled across the country and developed uniform principles, which are called the common law, shared among all courts. That tradition crossed the Atlantic and became the foundation of American law. So, when we study common law, we are really talking about a system born from centuries of case-based reasoning, refined through experience and precedent. But here's something many people miss. Early English courts were actually divided into courts of law and courts of equity. Courts of law could grant only money damages, compensation for a wrong, or handle eviction actions, since they are related to a property right. The courts of equity, however, handled cases where money wasn't enough. They could order specific performance, injunctions, or rescission when fairness demanded. Over time, these two systems merged, especially in the United States, following reforms such as the Federal Rules of Civil Procedure, but the distinction still matters, both for lawyers and for the bar exam. For example, under the 7th Amendment to the U.S. Constitution, the right to a jury trial applies to actions at law, but not to actable claims. So, if you are suing for damages in a federal court for breach of contract, you can demand a jury. But if you are only asking the court to compel the other party to perform the contract, that's specific performance, an equitable remedy, and the case will be decided by a judge, not a jury. If you are in law or equity, completely change your analysis. Thus, even today, we talk about legal remedies, money, versus equitable remedies, fairness-based orders. Now let's go back to what makes common law so unique, and honestly, so fascinating to study. First, there is the principle of stare decisis, which literally means to stand by what has been decided. Courts follow prior judicial decisions to keep the law consistent and predictable. So when a judge decides a new case today, they are not starting from scratch. They are standing on the shoulders of the cases that came before. Second, common law uses case-based reasoning. Judges look at how earlier courts handled similar facts, compare the reasoning, and then apply or distinguish those cases to reach a fair result. It is a little bit like building with bricks. Each decision connects to the next one, shaping doctrine piece by piece. And third, common law is all about flexibility. Because it's judge-made, the law can evolve organically through interpretation and adapt to social change. Statutory structure plus common law reasoning. For foreign-trained lawyers, this interaction between case law, equity, and status is often the hardest, most fascinating part of adapting to the US system. In civil law countries, we look to the code. In the US, we look to the cases interpreting that code. That's how legal reasoning is built in, through precedent, fairness, and legislation working together. If you want to go deeper into how common law, equity, and statutory law work across subjects, from contracts and torts to remedies in criminal law, you'll find full explanations, flowcharts, and examples in our Hours Bar Prep materials. They are designed especially for foreign-trained lawyers and busy professionals preparing for the California bar exam.